Picture this. You buy a brand new laptop. You open the box, you power it on, and before you can even connect to Wi-Fi, a screen pops up asking you to prove how old you are. Not on a website, not inside an app, on the operating system itself. That sounds like something out of a dystopian movie, but it is not fiction. It is a real law, already signed, already sitting on the books in California, with a deadline of January 1st, 2027. And it is only one piece of a much bigger puzzle that is quietly rewriting what it means to use a computer in America. This is not a story about one bill. It is a story about three separate fronts opening up at the same time: operating systems, VPNs, and app stores. And once you see how they connect, you will understand why some of the most technical, least alarmist people in the tech world, the kind of people who fix your Linux bootloader instead of panicking about headlines, are now the ones raising their hands and saying, wait, this doesn't work the way lawmakers think it does. Let's start with the operating system piece, because this is the one most people have never heard of. In October 2025, California Governor Gavin Newsom signed Assembly Bill 1043, officially called the Digital Age Assurance Act. The law does something no state has tried before. Instead of asking individual websites or individual apps to check a user's age, it goes one level deeper. It requires the operating system itself, the software that runs your entire device before any app even opens, to ask for your birth date or your age at account setup, sort you into one of four age brackets under 13, 13 to 15, 16 to 17, and 18 or older, and then expose that information through a live, constantly available signal that any app developer on the system can request. Not just Windows, not just macOS, not just Android and iOS. The bill's own language defines an operating system provider as anyone who develops, licenses, or controls the operating system software on a computer, mobile device, or any other general-purpose computing device. Read that again, slowly. That wording is broad enough to pull in Linux distributions like Ubuntu, Debian, Fedora, and Arch. And it is broad enough to pull in Valve's SteamOS, the operating system running on the Steam Deck, sitting in a lot of gamers' living rooms right now. Here's where it gets genuinely strange. Big companies like Apple, Google, and Microsoft have compliance departments, lawyers, and existing account systems tied to billing information. They can build an age bracket API without blinking too hard, even if they don't like the mandate. But Linux distributions are not companies. Most of them are volunteer-run projects with no account system, no revenue, and no legal department to consult. Debian doesn't have a sign-up screen the way an iPhone does. Arch doesn't ask for your birth date before you install a package. So when this law says every operating system provider must collect age data and pipe it to app developers, it is asking something of open source projects that those projects were never built to do, and in some cases may not legally or financially be able to do at all. One small BSD-based operating system called Midnight BSD has already responded to all of this by simply blocking access from California IP addresses altogether. Not because anyone forced them to. Because it was the only realistic way to avoid a legal gray zone they had no resources to navigate. Now, before you assume this is going to quietly kill Linux in California, there's an important update, and this is exactly the kind of nuance that gets lost in scarier headlines. After months of backlash from developers and privacy advocates, the same lawmaker who wrote the original bill, Assemblymember Buffy Wicks, proposed an amendment aimed at carving out an exemption for open source operating systems. So the law is not frozen in its original form. It is actively being renegotiated in real time, which tells you two things at once. First, that the original language really was written without much input from the open source world, since not a single major open source foundation is on record submitting testimony before the bill passed. And second, that public pressure from developers and tech commentators actually can move a bill like this, even after it has already been signed into law. Whether that amendment survives, and whether it fully solves the problem, is still an open question heading toward that January 2027 deadline. And this is exactly the kind of story that hardware and systems-focused creators, people in the same lane as Wendell over on Level 1 Techs, have been flagging as a bigger deal than it looks on the surface. Because this isn't really about pornography or social media anymore. Once age verification becomes something baked into the operating system layer itself, it becomes something every single app on that machine can theoretically query, whether that app has anything to do with age-restricted content or not. Your calculator app, your text editor, that random open source tool you downloaded from GitHub last week. The law's language says any developer who requests it, not any developer who actually needs it. That is a very different privacy conversation than a porn site asking for your ID. California is not acting alone either. Colorado has a nearly identical bill, SB 26051, which passed the state Senate 28-7 back in March 2026 and was waiting on a House vote to become law as well. And then in April 2026, things jumped from the state level to the federal level. Representative Josh Gottheimer introduced H.R. 8250, with Representative Elise Stefanik signing on as a co-sponsor, and this bill would require operating system developers nationwide, not just in California or Colorado, to verify user age at device setup and let parents attach content controls that flow through to every app on that device. Gottheimer's own press release framed this entirely around commercial mobile platforms, meaning phones and tablets from Apple and Google. But here's the twist reporters caught almost immediately. The official bill title itself does not use that narrow phrasing. If the actual bill text ends up matching the breadth of that title rather than the narrower framing in the press release, Linux distributions and other open platforms could end up sitting squarely inside a federal mandate too, not just a California one. That is a gap between what a bill's marketing says and what its legal text actually says, and that gap is exactly the kind of detail that decides whether millions of ordinary computer users are affected or not. So that's the operating system front. But there's a second front running in parallel, and it is arguably even more contentious because it targets the one tool most privacy-conscious people already reach for when they don't want to be tracked: the VPN. Utah moved first. Its online age verification amendments, formerly Senate Bill 73, was signed by Governor Spencer Cox in March 2026 and took effect on May 6, 2026. Here's the mechanism, and it's clever in a slightly unsettling way. The law does not ban VPNs outright. Instead, it says a user is legally considered to be physically located in Utah if they actually are physically located in Utah, regardless of whether they use a VPN or a proxy to make it look like they're somewhere else. That means a website can still be held liable under Utah law even if a Utah resident hides behind a VPN to access it, because the law simply refuses to recognize the VPN's spoofed location as real. On top of that, the law prohibits covered websites from publishing instructions on how to use a VPN to get around the age check in the first place. NordVPN, one of the largest VPN providers in the world, publicly pushed back, calling the approach a liability trap that punishes lawful privacy-conscious users everywhere, not just the small number of minors the law is aimed at. Wisconsin tried something even more direct. Assembly Bill 105, later becoming Senate Bill 130, sought to impose civil penalties directly on websites that host age-restricted content if those websites fail to block VPN access outright, not just fail to verify age. It passed the State Assembly's 69 votes to 22 back in March 2025 and was scheduled for a Senate vote in February 2026. Reports at the time noted the momentum looked strong enough that the bill had a real chance of passing. Now here's the piece that should genuinely surprise you, and it's a perfect example of why you need to check whether a story is fully resolved before you repeat it as settled fact. The Wisconsin VPN provision did not sail through. Reporting on the bill's progress noted the direct VPN blocking language faced heavy backlash and was ultimately scrapped, even as Utah's more indirect approach, targeting liability rather than the VPN itself, survived and went into effect. That is not a small distinction. It tells you state legislatures are already testing different legal strategies against the exact same problem, and some of those strategies are proving far more durable than others in the face of public pushback. Digital rights groups have called this entire trend a technical game of whack-a-mole, where every legislative fix creates a new workaround, which then invites a new fix, on, without ever fully resolving the underlying tension between protecting minors and preserving privacy for adults. Which brings us to the third front, the one that started all of this in the first place, and is honestly the most legally settled of the three: app stores themselves. Texas passed the App Store Accountability Act, Senate Bill 2420, requiring Apple and Google to verify the age of every single user before they can even create an account, not just before downloading a specific age-restricted app. That took effect January 1st, 2026. Utah and Louisiana followed with similar laws, taking effect May 7th and July 1st of 2026, respectively. Apple, through CEO Tim Cook, actually lobbied Governor Abbott directly to veto the Texas bill, arguing in a public statement that requiring the collection of sensitive personal information just so someone can check the weather app crosses a real privacy line. Abbott signed it anyway. Apple then complied by building a declared age range API, and Google built something similar called the Play Age Signals API, both designed to let developers query a user's age bracket without Apple, or Google, having to hand over a person's actual government ID to every app on the store. The legal foundation underneath all of this, by the way, is not shaky. In June 2025, the Supreme Court ruled 6-3 in Free Speech Coalition versus Paxton, upholding Texas's earlier age verification law for adult content, with Justice Thomas writing that the law only incidentally burdens the protected speech of adults, which is enough to survive intermediate scrutiny. That ruling is the legal green light that a lot of these newer state laws on operating systems and VPNs alike are quietly leaning on. In May 2026, the Supreme Court declined to intervene again, letting Texas continue enforcing its App Store law after industry group challenged it on constitutional grounds. So this is not a fringe legal theory anymore. It has already been tested at the highest level, and it has already won. Here's the honest, complicated part, the part a lot of coverage skips because it's less dramatic than the government wants your ID. Nobody actually agrees on whether any of this works. Supporters point to research linking early exposure to certain online content with real mental health effects on kids, and they argue age checks are a reasonable, narrowly focused response, especially now that the Supreme Court agrees the burden on adults is only incidental. Critics, including the Electronic Frontier Foundation, argue the opposite just as forcefully, saying that courts have already blocked plenty of these laws on First Amendment grounds when applied to broader categories like social media, and that pushing verification down to the operating system or blocking VPNs outright just creates a much bigger privacy exposure for every adult on the system, in exchange for protection that a curious teenager can often still get around anyway. Experts genuinely differ here, and some of the state-level social media laws specifically have already been struck down in court, even as the adult content and App Store laws have held up. So where does that leave someone just trying to use their computer normally in 2026? It leaves you in the middle of three overlapping systems that were not designed together, being built by different legislatures on different timelines, using different legal theories, and colliding into each other in ways nobody fully planned. An operating system law in California that might not even survive contact with open source software in its current form. A VPN law in Utah that survived, next to a nearly identical one in Wisconsin that didn't. And an App Store framework that the Supreme Court has now backed twice, quietly becoming the most stable ground of the three. None of these pieces are finished. The California amendment is still being negotiated. The federal bill's actual text hasn't been fully tested against its title yet. And more states are almost certainly going to introduce their own versions of all three approaches before this year is out. What started as a handful of state laws about pornography sites has, in less than 3 years, worked its way down into the operating system, running on your phone, and up into a proposed federal mandate that could touch the software running underneath everything you do online. Whichever side of this debate you land on, that is the part worth sitting with. If you want to actually keep up with where each of these three fights lands next, that's exactly why it's worth hitting subscribe. Because this is one of those stories that is going to keep changing shape for the rest of this year.